Hello friends, welcome back to my channel. Now, today's topic will be visa rejections. Let's talk about that. A lot of applications are refused every day. Lot of applications, whether it is visitor visa, work permit, study permit, open work permit, permanent residence. There are a lot of applications that get refused. Now, most people, they don't know that there can be an appeal mechanism to fight your case. Let's just say that if the application is refused, many people don't know that you can appeal that decision of the officer to the Federal Court of Canada. That is called a judicial review. So, what is exactly a judicial review? How is the process? How is it done? What is the timeline? I'll be answering all these questions today. Okay, so let's just say that if a visitor visa is refused or a study permit is refused, and normally whenever we apply for the reasons of the rejection, we normally find that visa officer has done injustice to our application. Visa officer has not focused on particular aspect of the application, particular document of the application. Sometimes we feel that, okay, even though we have submitted sufficient financial resources, still the visa officer has come up with a decision negatively and come up with the reason for refusal to be finance. So in that case, I mean, whenever we feel that we have submitted sufficient documentation in support of our application, still the visa officer has not considered the evidence, or let's just say that visa officer has not given us a procedural fairness. Now, procedural fairness, what is a procedural fairness is a separate topic. I'll discuss that in the next video. But let's just say that if you're not happy with the decision of the visa officer and you find flaws in the assessment of the officer, not only happy, I mean, if you are not simply happy with the decision, you cannot appeal it to the federal court. No, that is not the topic of this video about. No. The thing is, if you find that visa officer has made serious errors while assessing the application by ignoring the evidence that you have presented in the application, then, or let's say if the visa officer has failed to give you an opportunity to respond when there were credibility concerns in the application, when there was a procedural fairness requirement in the application and still you were not afforded procedural fairness, this is when a judicial review may be possible. It depends on case-by-case basis though. Not every case qualifies for a judicial review because the prima facie, if your initial submission is not good, if your initial submission has flaws in it, then you cannot go appeal that decision. In that case, I would advise, if the initial submission is not good, then I would advise to perfect the application properly. I mean, do the application properly, prepare the explanation letter properly. If everything still doesn't work out, then go for an appeal at the federal court. Now, not a lot of people know that visitor visa can be appealed, work permit, it can be appealed, study permit, it can be appealed, permanent residence, it still can be appealed to the federal court. There are various grounds for judicial review. So we cannot really determine without looking at the application what can be the grounds or whether this application can be submitted and appealed for. So what is a judicial review? What is the length a judicial review normally take? My bad. Yes, I will discuss how much does it normally take for a judicial review application to get assessed, or a judicial review application to go through the court and get a decision. Normally, it takes about 7 to 10 months. It's long, but in some cases, when there are repeated rejections, even after submitting the explanation letters, even after submitting the proper financial documents, proper study plan, everything is there, still the application is getting refused repeatedly. In that case, judicial review can be an option. I would not really recommend doing a judicial review after one application refusal, especially when it is a visitor or work permit or study permit rejection. You can always submit a reconsideration, or you can always submit a reapplication for that. But if it is 2 or 3 times rejected for the same reason, for different reason maybe, but I mean, if it is still getting refused even after submission and even after explanation of all the documents, still it is getting refused, then judicial review is your option. Now, how does it work? The overall process time, it takes about 7 to 10 months. First, let's talk about the deadlines. If you are located outside Canada, then the deadline to file a judicial review application is 60 days, 60 days. If you are located inside Canada at the time of the decision, and the decision, okay, so if you are out inside Canada at the time of decision, then you have 15 days, 15 days to submit the judicial review application. Even if you have missed the deadline, if you have continued interest in pursuing that litigation, there is a test for that. But if you have intention to pursue that litigation against IRCC, in that case, court may grant an extension, but you have to request an extension according to the rules of the court. So this is the deadline portion. You have to submit the application within 15 days if you are located inside Canada at the time of decision, and 60 days if you are located outside Canada at the time of decision. Once you submit the application, the next step is the IRCC lawyer, so basically Department of Justice in Canada, yes, sorry for the interruption. So as I was saying, the first step is, once you submit the application for leave, the first step is you will get a notice of appearance from Department of Justice. So basically, your lawyer is representing you in the federal court. IRCC is represented by the Department of Justice, and so basically you get a notice of appearance from the Department of Justice as soon as you file the leave within 10 days. Within 10 days of filing the application for leave, you will get a notice of appearance. After that, if you have mentioned in the application for leave that you haven't got the reasons for the refusal, the court will send you the Rule 9. The court will send you the reasons for refusal. That will have the detailed explanation of the visa officer, the notes of the visa officer. GCMS notes in this is similar. So once you have the notes, then you have 30 days to submit the applicant's record. Applicant's record means your written memorandum of arguments on why you believe that the application was unreasonably denied, or what kind of factors the visa officer should have taken into consideration that he did not or she did not. It is your memorandum of argument. It is the documents that you want to submit along with that. And it is basically your argument on why you think that the decision was wrong. Then, once you submit that applicant's record, within 30 days, the respondent, that means the Department of Justice, a lawyer is appointed on behalf of IRCC to fight against your application, and So respondent sends us their portion of the argument, saying that okay, so basically we are saying that no, the decision of the visa officer was wrong, and the government lawyer is saying that no, the decision of the visa officer should stand because he did not or she did not make any reviewable error in the assessment of the application. Then once you have that respondent's memorandum of argument, the next step is submission of the reply. So basically we get to reply the argument of the respondent, and then once you submit the reply, then the whole package, all three arguments, go to the judge of the federal court, and the federal court judge decides whether to admit the matter or not, or in other words we can say whether to grant the leave or not. If the leave is granted, then a hearing is scheduled, and your lawyer or you can appear in that hearing and explain to the judge why you believe that the application was denied unreasonably. And if the judge believes that okay, the application was truly denied unreasonably, or the visa officer has committed reviewable errors, in that case the judge will direct IRCC to reopen the matter and assign it to a different visa officer. This is the process. Now, another thing can also happen. Once you submit the arguments, once the government lawyer submits their arguments, once you submit the reply, after reviewing the package, the federal court judge may say that no, this case cannot, the leave cannot be granted, it cannot be admitted. So in that case, the case can be dismissed at that point. That means we don't have any remedy after that. And after that, let's just say even if the leave is granted, after the leave is granted, the matter goes to the hearing, and even after the hearing, the judge can say that okay, the matter is dismissed. In that case too, we don't have a remedy unless there is a certified question. Then we have an appeal right. So this is the process. If the appeal goes through, if it is positive, if it is allowed, then federal court basically directs IRCC to reopen the application, and another visa officer assesses this application. And in that case, there are high chances that the application will be approved. Again, it is not 100%. The visa officer still can refuse the application on other grounds. He can still refuse the application. So a judicial review is not an ultimate remedy, but still, if you are facing repeated rejections, and if you want the court to hear your matter, this is the option. Federal court is the way we can present the matter, and in this way the matter will be assessed judicially. So basically we are requesting the court to judicially review the decision of the officer. This is one way of appealing the visitor visa, work permit, study permit, permanent residence, or any other kind of application. If you have further questions, I do judicial reviews all the time. If you have further questions, reach out to me. My contact number is mentioned below. Thanks for watching.